The idea of intellectual property can sound overwhelming. Patents, trademarks, copyrights, and how can we possibly cover what takes multiple semesters in law school in just a few short minutes here? Well, here's how. We're going to cover just what you really need to know. How do you spot the issues? We're not going to walk you through everything an attorney needs to do, but we're going to talk about how do you protect one of your most important assets, intellectual property. What's a copyright? What's a trademark? And more important, how can you as a business owner understand enough to make sure you are protecting these important aspects, these important assets in your company? Every company has trademarks and copyrights associated with it, or at least nearly every company. But a lot of business owners don't know that. And so today, we're going to unlock the ideas of trademark, copyright. We'll touch on patent a little bit. We're also going to identify what are the items in your business that can be protected. When we're done with this short time, you will walk away having identified what can you protect in your business by copyright, trademark, and patent. And you'll have a plan of action on how to go about getting that protection if you even need to. A lot of times you have protection built in, and I'm going to talk about the protections available to you for free. First, let's talk about copyright. I think you'll find once you understand the purpose for copyright, it will all make sense. It will go from feeling like a bunch of legal terms to, I get it. You'll have an epiphany that will help you see copyright all around you. In 1665, Queen Anne was born. She was the monarch over Great Britain and Ireland. She did something that will forever change intellectual property law. Queen Anne only lived 49 years, but at the ripe old age of 45, in 1710, she enacted the Statute of Anne. This was the first statute that established copyright law. Basically, the law said, those who are artists, who create art, have a right to control their art. They have a right to control if it's copied, if it's used, and what that looks like. We're going to call that copyright, the right to control copies and subsequent use of your art. So, the idea behind copyright is to protect the rights of artists. Did you know that the copyright idea was included in the United States Constitution by our founding fathers because they wanted to make sure that this important intellectual property right was established in the founding document for our country? I'll read it to you. It says, "To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries." Now, the reference to inventors and discoveries, that's patent law. We'll cover that later. But for now, we're talking about artists. So, when an artist creates something, they automatically get a copyright to it. That means they automatically get a right to control the copies. So let's talk about what kind of works could an artist create that would be protected. It's any art, and that's very broadly considered. Let's take a look at some examples. Here we have an album for a record player. Let's take a look at this. We have an album cover. Is that cover protected by copyright? Certainly. What about the photo that was taken of these individuals? Is that protected by copyright? Yes. Photos are protected, the cover is protected, the music is protected. All of that was created by artists, perhaps different artists. And that means there are different copyrights associated with each one of those works of art. The photo, the design, the music. And by the way, even with music, you have the written composure of the music, and you have the recording of the music. So there are two different aspects of art that are fixed into a tangible medium. In other words, you have the composure, you have the recording. Both of those, which could be by different artists, are protected by copyright. Let's take a look at some other examples. Here you have a movie, the movie of Annie. The movie itself is protected by copyright. Each song on there is protected by copyright. There might even be other aspects of the movie that are protected by copyright. The cover art is protected by a copyright. The cover of the album, or at least the logo here, is protected by copyright. What about a game? A video game? Certainly, software code is protected by copyright. Why? Because there's artistic elements to that, how that software code is put together. Likewise, the cover here is protected by copyright, and there might be different copyrights. For example, the company that put together this logo, that company might be different from the company that put together this logo. So you might have a copyright in this logo, copyright in this logo, and maybe all sorts of different images here might have separate copyrights. What about books? Yes, the text within this book is protected by copyright. Any images in the book is protected by copyright. The cover art is protected by copyright. What about interpretations? This is one of my favorite versions of the Bible, the Message. It's a different interpretation of another work. The original work may be thousands of years old, but you have a more recent interpretation. Is this protectable by copyright? It certainly is. Interpretations or translations are protected by copyright as well. What about this notepad? Well, on one hand, you have a little logo up there, so that's protected by copyright. But what about the lines, the placement of the lines here? Some graphic artist had to put that together. So is it protected by copyright? Well, courts have struggled with this and ultimately said, look, there has to be some element of art to it. It's not enough to just have a functional purpose. There needs to be some artistic aspect. Now, if you look closely, there are two lines going down the side here. Perhaps there's a little bit of artistic creativity in having two lines instead of just one, whether it be a bold or thin line. But frankly, that's going to be pretty hard to argue in favor of copyright because there just isn't much more than a practical aspect to this. So keep in mind, the idea of copyright is to protect creative works, but not all works. There has to be an element of creativity to it. What about this keyboard, this typewriter? Is there any copyright associated with this? Well, if you look at it, this is definitely more than just functional. There's some colors and there's some design elements on it. There's at least some element of copyright here. What does that mean? It means nobody could exactly replicate this without violating copyright. Now, could somebody use similar colors and still make a typewriter like this? Sure, it'd have to look different though. It can't be copied from this. Now you might be asking, what happens if two artists independently create something that looks very similar or sounds very similar? In those cases, is that a copyright violation, which we call infringement? No, that's not infringement because the right to copy or control copies only relates to copies and use of a person's work. It has nothing to do with the independent creation. Now, you might have an argument over whether the person was inspired by somebody else's work and maybe subconsciously saw that and then created something that was, in essence, a copyright. But that's an issue of evidence. Was it actually copied versus independently created? So that means, in theory, two artists could create something that creates incredibly similar, and as long as it wasn't copied from the other, the artists have no copyright infringement. But if you sit and look at a piece of art and then create something from that, or if you listen to a song and then create a song from that, if it's too similar, it is likely going to be considered copyright infringement. We'll talk a little more about some of the considerations there. As a business owner, you might be wondering, well, what happens if employees in my company are paid by me to create something for the business? Does the employee, who's the artist, own the rights to that? Well, it wouldn't make sense to let all employees own that right. So the law has developed a concept called work made for hire. In other words, you can hire employees, and any work created by that employee while working within the scope of business is going to be a copyright owned by the company because the company is paying the employee's wages. But if the employee does something after hours, maybe creates a painting, and it has nothing to do with the business, do you as the business owner own the rights to that painting that the employee created after hours? No. The employee can do something outside the scope of business on her or his time, and that work is not owned by you as the business owner. One little related item to this: what if you hire another company to create something for you? Who owns the rights to this? Well, as you may recall, the company who created it owns the rights to it unless a contract that you entered into with that company gives you the intellectual property right to what they created. This is sometimes called a work made for hire contract provision. Now you might be thinking, wow, this is cool. Does a copyright protect essentially ideas? Because essentially all these things, music and video and art, they're really ideas. The law says no. Ideas are not protectable by copyright. The idea must be in a fixed, tangible medium. In other words, it must have gone from idea stage to a recording, paper, a canvas, digital code, something that is somehow represented in the physical world, not just a concept or an idea. Ideas are not protectable by copyright. Only the form of that idea that is in a fixed, tangible medium, a physical property of some sort, and that includes the digital physical property. So if it's on a computer, or it's a music stream, or a video streamed from YouTube or whatever, that digital element is protectable by copyright, but the mere idea is not. Now you might be wondering, what rights do I have to buy copyright rights from someone else or sell the rights to copyright? We already talked about the fact that you can hire a software designer, a graphic designer, or somebody else to create work for you, and under a work made for hire provision, you would own the copyright, not that other company. And by the way, if you're a company that's creating any sort of artwork for anybody, this is important for you to know. Or if you're creating software code for people, it's important to decide who owns the rights to this and have that delineated in a contract with you and your client. So what are your options for selling your work? Let's talk about this. Well, first off, you can sell the copyright outright. That's sometimes called an assignment, but assignment is just more of a fancy name for transferring or assigning the rights to another party. But let's say you want to keep the ownership, but you want to give somebody else permission to use the work. And maybe your permission to use is for a very specific purpose. What's an example? Let's say you recorded a little guitar tune that you made up. And that recording you want to allow somebody to use as background on their video. Well, that permission to use is called a license. License is just a fancy word for a permission to use intellectual property. So, if you give that person permission to use your music on their video, you would be giving them a license. This permission can be provided orally or can be provided in writing. We would call it a license as lawyers, but you can call it whatever you want. So even if you say, hey, yeah, you can use my music on your YouTube video as a little background music, no problem at all. What we have established there is a license for copyright use to your musical composure and your musical recording, so there are two elements there. And that license is limited to the YouTube video for which permission was granted. In other words, it's not a license to go sell that music and allow it to be used on other videos or other purposes. A license can be limited. So keep in mind, whenever you give somebody permission to use work or you get permission to use some sort of copyrighted work, you want to make sure you're thinking about what is the scope of that use. And ideally, you have that written down. That might be called a license agreement. That's typically what the contract is called, that governs what are the terms of somebody else using a person's intellectual property rights. So let's recap where we're at so far. In order to protect artists, and we mean that term very broadly and liberally, whether it's music or graphic design or software code or anything that has some sort of creative element, copyright law was established. Copyright law immediately gives the right to control copies and use to artists, the artists who created it. Now, if that artist works for a company and is being paid for that work under the work for hire doctrine, that copyright is owned, or the intellectual property right is owned by the company. So the idea though is all about artists and protecting artists' rights, and artists have a right to transfer those rights to other people. That's either an assignment of an entire copyright, or it's a partial authorization, an authorization to use or make copies of what the artist has created. We call that work, the artist's work. And whenever you give permission to use, that's a license. So copyrights are everywhere. You might be asking though, what about public domain? What about stuff that's really old and it's become part of the public domain? Is that still protected by copyright? The answer is no. Under the copyright law, the idea is that nobody else can use the artist's work for a period of time so that the artist can recoup compensation or some sort of reward for the benefit to the public. In other words, the artist has created something for the public. For a period of time, the artist can benefit by controlling that. So maybe getting royalty fees. That's just a fee for somebody else having a license, which is permission to use the work created by the artist. But after a time, and this is typically well after 70 years, that right to control copies and use evaporates. The artist gets a right for a period of time, but then after that, it goes into the public domain and can be freely used by the public. Public is just anybody. Domain means ownership or control or the possession of. And so essentially, instead of the right to control being owned by the artist, now the right to control is owned by the public, and it can be freely used. Funny story though, there was an artist who decided, I'm not going to wait until the end of the copyright before I give up my rights. I'm going to transfer my art into the public domain. Then another company took that art and put that art in a collection of stock photos and images, and then charged people for use of that. In fact, the artist who created this work got a cease and desist letter from the company who said, hey, you are using our art. And the artist sued and said, no, that's mine. I put it into the public domain, and you don't have a right to take it out of the public domain. The court actually said, well, the artist has a right to control that, and she had a right to put it into the public domain. But to the extent somebody else wanted to create a copy of it and charge for those copies, they have a right to do that now because it's in the public domain. One great example is if you look at books that were written hundreds of years ago. Anybody can make a copy of those books and sell them at a bookstore. Now, if you want to add some new artistic elements to it, like you want to make it current English, make it a more contemporary version, you have a right to do that. You don't have to pay the original owner of the copyright because it's now in the public domain. And your new changes here are called derivative works. That just means your work was derived from someone else. Your new copyrighted work, your updated version, was taken from somebody else's previously created work. And now you own the copyright in that newly created work. Can anyone else copy what you've done? No. They, of course, can go back to the original, which is a couple 100-year-old manuscript that's now in the public domain. And other artists can go take that and create their own version. That's fine. But they can't copy your version. When you understand the concept here, it's protecting the rights of an artist for a period of time so that artists can be benefited by producing art. Then we better understand how copyright works. And it will be much easier to understand how copyright is different from patent and trademark law, which we'll talk about shortly. So what happens if somebody else infringes your right as an artist? In other words, what happens if somebody violates your copyright? Well, you can sue them for copyright infringement, but there's a requirement first. Before you sue somebody for copyright infringement, you need to register your copyright. So although you have a copyright, it's not a registered copyright. It's what's called a common law copyright. So your right needs to be registered in the U.S. Copyright Office, and typically you can do this without an attorney. You pay a $35 filing fee, at least that's what it's been. You file it. No lawyer looks it over. Nobody in the Copyright Office is going to scrutinize whether you have a right to it. All you're doing is putting a little file in the U.S. Copyright Office that says, hey, I'm claiming a right to this. Now, whether you actually have a right is something a court would decide later on if you sue for copyright infringement or somebody else sues you. So keep in mind, when you file a copyright to register it, that copyright is not being scrutinized. It's just being recorded, and now you can put the R with a circle on it next to any copyrighted work you have. You can tell people this work is copyrighted. This painting is copyrighted. This song is copyrighted. This video is copyrighted. This software is copyrighted. It's a registered copyright, because once you have filed with the U.S. Copyright Office for a registration of your work, you now have a registered copyright, not merely a common law copyright. And that gives you the right to sue for copyright infringement. But if somebody infringes your copyright, do you want to go straight to court and spend all that money on legal fees? Often you don't. Usually the best practice is to send a letter to the other side, whoever is infringing your copyright. We might call that letter a cease and desist letter. We might call it a demand letter. The title we give it isn't very important because basically what you're saying is, hey, you better cease and desist or stop using my copyrighted work illegally. You're infringing my copyright. Now, can you send a letter to the other side even if you haven't registered the copyright? Absolutely. Because you still own the copyright, you just haven't taken the next step of registering the copyright. So you are welcome to send a letter to the other side. Now, sometimes this is called a demand letter. Why do people call it that? Because you're demanding that they do something. You're demanding that they cease and desist. You might even demand that they pay you some money in order for you to avoid suing them. So the letter might say something like, you are infringing on our copyrighted work. This is our work. Here's the evidence that we have that you are using it without our permission. We can sue you for copyright infringement, but in the interest of saving everybody legal fees, we'll accept some money in exchange for not suing you. Usually a cease and desist letter or a demand letter or whatever you want to call this letter is sent by a law firm. Why? Well, a law firm doesn't have to send it, but if you send it yourself, it may not carry the same weight. It may not demonstrate the same seriousness that you're hoping to convey to the recipient of your letter. The purpose of your letter is to get the other side to stop infringing your copyright. And they are most likely to take that letter seriously if it comes on law firm letterhead rather than merely from your company. But sometimes you might say, hey, let's give it a try. Let's send a first draft off. A letter like this can very easily be created with artificial intelligence, or you can find a template online which you can use. You can send it like that. I do find most of the time the recipient of a letter regarding copyright infringement ignores that letter unless it comes from a law firm. And even then, the recipient may ignore the letter. And at that point, you need to decide, are you going to sue for copyright infringement? And that's a conversation to have with your attorney. Many times, small businesses decide it's just not worth spending the money to sue for copyright infringement. Here's one of the problems. You may not be able to recover any of your attorney's fees. So you might spend $50,000 to $100,000 going after somebody. And let's assume they clearly infringed your copyright. And let's say you win the case. And at the end of the day, the judge says, all right, I find that the defendant infringed your copyright. I'm going to award $8,000 in damages. And by the way, that's not uncommon. In other words, quite regularly, the amount of the award is far less than the amount of money that was spent on attorney's fees in litigation. And so as a practical matter, most of the time, it doesn't make sense to sue a single party for infringing your copyright. Now, if they're infringing hundreds of your copyrights, or if it's willful and wanton and egregious, you might be able to recover your attorney's fees. In other words, let's say you're an artist and you create paintings, and some big company rips off all your paintings and starts selling digital art with your paintings, or even creating canvases with your paintings, and they're generating tens of thousands of dollars by including your paintings in their collection of art being sold online. That's a great example of where their conduct is willful copyright infringement. It's wanton, meaning it's excessive. It's egregious. And in those cases, often you're able to recover attorney's fees. And keep in mind too, you're often able to recover damages for every single infringement. So each work that's infringed and each time it's infringed. But this is a conversation to have with an attorney, because you can talk with an attorney about what are your costs potentially in actually pursuing this to trial. What is your likelihood of winning? And what is the amount of damages or money you're likely to get awarded in this case? And by the way, too, once you get that award, which is a piece of paper from a judge, what's the likelihood you can actually collect it from the other party? I mean, let's face it, if somebody's in another country, it can be very difficult to collect an award because you have to transfer that award to that country. We have to have a treaty with that country that allows for the enforcement of a United States judgment in that country. Now, if it's a Great Britain, no problem. But if you're talking about one of the small countries in Africa or Russia or some of the other countries that are in less developed portions of the world, it is unlikely that you are going to be able to enforce a United States court judgment that says you're owed money in those countries. So all of these are practical considerations, but at least now you have an idea on what does the copyright law give you as far as rights as an artist, and what are your practical options when somebody else infringes on your rights as an artist. Now there's probably one more topic you're wanting to know about, and that is fair use. What is fair use? You've probably heard a lot of creators online talking about fair use. Fair use is a defense to copyright infringement. So if somebody is using an artist's work without permission, they are infringing that artist's copyrights. But there are times when infringement is permitted. In other words, there are times when use is fair. And that's the fair use doctrine. Keep in mind, fair use is always an infringement of somebody else's copyright. But under the United States copyright law, there are certain types of infringement that are going to be permitted, or certain types of use that's going to be considered fair or acceptable. So fair use is simply permitted infringement of somebody else's copyright. What are some categories? One example is if you are giving commentary or reviewing or criticizing the work of an artist. So for example, if a YouTube creator decides to critique and criticize a painting and is showing that painting and saying how the painter did something wrong, on one hand, you clearly have a painting which is created by an artist. We assume there's a copyright in that painting. So if it was made in recent years, there's clearly a copyright in that painting. And a copy of that painting is being shown on a digital video as the YouTube creator displays it. So you clearly have infringement of a copyright by showing a copy of that painting on a video. But when the purpose of the video is to critique or criticize or comment on the painting, whether the creator is saying, oh, the painter did this well, or the painter did this poorly, that is considered fair use. So that's one example of when it is okay to make a copy or use the work of an artist without their permission. Now you might be saying, oh, isn't that interesting? So I could create a video of a movie. I could put myself in that video and comment on that movie from time to time, and that would allow me to freely make and sell copies of that movie? No. There are limits to this, And a court will look at how much of the work did you copy, to what extent did you take away the financial benefit to the owner of the work, like in this case, a movie production company. And how much are you really changing that work of the artist in your effort to provide value on commenting? So if you commented over an entire movie and didn't play the movie audio, and you just kind of explained what the producer of the movie or the director of the movie or the actors were doing, that would be commentary, and that may be allowed. But if you let somebody basically get the full experience of that movie by having the audio and video fill up the screen, and you're just sitting in the corner occasionally commenting, that is insignificant. That is not sufficient to establish fair use. So as you can tell, it's a gray line. There's not this bright line test. Oh, that's fair use and that's not. Fair use is considered by a judge after you've been sued for copyright infringement as a defense to why you should be allowed to infringe. And that essentially is because you are making a legitimate good faith use of a part of the fair use law. Let's talk about some other examples of fair use. The next category is news reporting. When covering the news, reporters are allowed to display images that are copyrighted. The idea here is that we don't want to stifle or freeze news reporting through our intellectual property laws. We want news reporters to be able to provide the value of reporting to the public without having to pay out money to artists who have created work that ultimately appears in a news story. Another category of fair use as a defense to copyright infringement is parody. Parody is a difficult area. It's a very gray area. But the idea is basically you can create some comedy out of something that's copyrighted, and you're significantly transforming that work of an artist to create a new form that involves some sort of parody. And when you do that, there's some protection here. But this is an area where you have to be really careful, because courts have often found there wasn't a sufficient parody element to benefit from the fair use defense. And so parody often is insignificant if you are trying to claim fair use. You need to have very clear parody and a very clear change in the original work of the original artist. Another example is educational purposes. This video is educational. Previously, I showed the cover of various books and other items. In essence, I am providing a copy of this book. So, because I don't have permission of the owner of whoever created this book, I have now infringed the copyright of the owner of the front of this book. Now, that might be a different owner than who actually created the text of the book. I didn't infringe the text because I didn't read it all. I didn't provide a copy to you. But as far as the cover, I've clearly infringed the copyright of the owner of this book. But I did so for the purpose of education. It didn't take away any sales of the book. In fact, it probably helped the sale of the book, because this is a fantastic book for business owners. But I clearly infringed. As an educational video, this clearly qualifies under the educational category of fair use. Thus, this is copyright infringement that is permitted under the fair use doctrine, and I would not be liable if I got sued by the owner of this book cover for copyright infringement. Clearly, this is an example of educational use that's fair use. Another factor courts will look at is, was the copying without permission, so the infringement, done by a for-profit company or nonprofit? Was it done to benefit the public without any financial motive, or was there some sort of financial benefit to whoever did the copying? That'll be a factor considered by the court, because if you're making money off the art of another, the idea with copyright is that should be shared with the artist, or it should be exclusively the right of the artist. One other thing to keep in mind is that if you significantly transform the art from one medium to another, a court might say that transformation is enough to argue for fair use. I'll give you an example. Let's say I read a sentence out of this book. I didn't copy the whole book, but I clearly copied one sentence. So clearly we have copyright infringement of that sentence. That's undisputable. But did I really undermine any sales? No. I didn't take the whole book. I just read a little sentence. I transformed what is an entire book into simply a video with a copy of one sentence. And the courts will say, because you only took a little element and it's such a different medium, it didn't take away any sales, and in this case, by the way, it's educational as well. All of those reasons would argue in favor of fair use. Now, you might be saying, wow, Aaron, you're giving me a lot of factors to consider to think about fair use. I would really like some just general rules, like this is fair use, this isn't. Unfortunately, fair use isn't that way. The courts and Congress have specifically designed the law so that many factors can be weighed by a judge. As a result, if you decide to violate the rights of another artist, so you decide to infringe a copyright, you're going to have to demonstrate in court that your right to use the artist's work was permitted by fair use. In other words, clearly you've infringed a copyright. Now you have to raise the fair use defense. Maybe you'll win, maybe you'll lose. But there's always a risk if you're going to use somebody else's work without their permission that you may get sued for trademark infringement, and you're going to have to demonstrate, you have the burden to show that under fair use law, you should be allowed to do that without actually having to pay money to the artist. So let's recap. Anytime an artist creates anything, they immediately acquire a copyright. When an artist creates a work, the artist owns the right to that work, including any subsequent use or copies. The artist can give permission for somebody else to use copies. That's called a license. The artist can sell the copyright entirely. That's called an assignment. If somebody else infringes the artist's rights, the artist can send a cease and desist letter or demand letter, or the artist can sue for copyright infringement, but only after registering the copyright. Remember, in order to get a registered copyright, you need to file in the U.S. Copyright Office. You can generally do that without an attorney, and by registering, you get the right to sue and some other rights that go along with that. That's the gist of copyright law. The whole idea is to protect artists and the work they create. So whether you and your company are creating artistic works, or you're using the artistic works of others, you now know people have to pay for the right to use that. You can get a copyright registered if you so choose, or you can just live with the idea of not having a copyright registered. A lot of times small businesses don't spend the money to register a copyright unless they get close to the timing of suing. Whether you actually want to do that is a great question to have discussed with your attorney. So that's it. That's copyright law in a nutshell. You now know all of the key things that a business owner needs to know to identify what stuff in your business can be protected by copyright. You've identified who has the right to that. So your company, if your employees create it or if somebody else created it, they have the right to it. And we've talked about how do you get permission? Well, if you want to get permission from the owner of a copyright, you typically pay for a license. So like if you buy a copy of Microsoft Word, you're getting a license to that. And a license can be for software as a service. It can be for digital products. It can be a right to use for a period of time. There can be all sorts of limitations on the right to use somebody else's work. We call that a license. We call that license terms. So now we're going to transition from the rights of an artist, which we call copyright, to the rights of somebody who is selling a product or a service. And when somebody selling a product or a service uses some sort of brand name or brand mark, we call it a trademark. Actually, in the case of selling services, we call it a service mark. And in this circumstance where we're selling products, we call it a trademark. But often we'll just call it trademark generically so that we don't have to differentiate every single time between a service mark and a trademark. Because generally speaking, even if a mark is for services, the same law applies for trademarks to service marks as well.